What we have achieved is the following. We have provided, I think, a very honest restatement of the law applicable to air and missile operations during armed conflict, because there is no specific treaty that deals with these aspects. And there is another private draft which dates back to 1923, and you can imagine that in light of the technology that has developed, of course, and certainly since 1923, there was a desperate need to compile it in one document and to provide it to those who are working in the field. The group was very diverse, and one, well, you could call it result or insight was that at the end of the day, the entire group, even though they came from different backgrounds, were able to agree on all the rules that you find in the manual. So you have representatives from the ICRC, you have government representatives, you have academics, and this is quite extraordinary to have such a big group be able to agree on a wording of a specific rule. And there is not only one rule, as you of course know, there are many rules in the manual, and they all are based on a unanimous consensus of those experts. I think we are very often obsessed by the novelty of technologies, believing that a new technology needs new rules. But as rightly stated by the International Court of Justice in its advisory opinion on the nuclear weapons case, also the experts agreed that the novelty of the technology doesn't change anything and does not necessarily require new rules. But what we did, in particular in the commentary, to address these issues when it comes to the application of a given rule to a given technology, like, for example, automated weapons or hypersonic weapons, and so on and so forth. First of all, I would advise those legal advisors, or all of those who are interested in the topic actually, to read the entire manual plus the commentary. Because just reading the manual would not be sufficient, for a simple fact. As you know, with law, you can have different interpretations. And for the legal advisors, it is very important to know the commentary, because in the commentary you will see reflected the different positions taken within the group of experts. Why is that important? It is important because at the end of the day, the legal advisor will have to reconcile his legal advice or her legal advice with the respective government position regarding the applicable law. So in that regard, the commentary of the manual also offers options to governments and government officials, in particular legal advisors, to have an arguable position with regard to the applicable law in a given situation. Operators have a keen interest actually in the applicable law. They want to be certain that what they are doing is in compliance with the law of armed conflict. So they would also be taking a keen interest in anything that is related to their operations, including the law.